Now I request everyone to put on their phones on the silent mode, please. We have a few instructions, so I'll just read out these instructions. Each speaker is given 45 minutes, out of which 30 minutes is for their presentation and 15 minutes time is allotted for the question and answer session. Alert bell will be sounded 5 minutes and 1 minute before their time ends. The participants are requested to ask one short, crisp and clear question each so that everybody get a chance. Thank you. Now, moving on to the next event of the seminar, I would like to call upon Divya to introduce the first speaker of the event. Divya.
Good morning, everyone. Sneha Nagraj, a partner at Frontier Legal, has a wealth of experience in various legal domains, particularly in dispute resolution, arbitration, and real estate. A graduate of Christ College of Law, Sneha obtained her bar license from the Bar Council of Karnataka in 2011 and is also a member of Chartered Institute of Arbitrators UK. A significant aspect of Sneha's work involves her contribution to apartment associations. She has been instrumental in forming associations, conducting legal audits, overseeing handovers, and performing title diligence of land and buildings. She also represents these associations in litigation and arbitration against builders and third-party vendors before the High Court of Karnataka, RERA, civil courts, consumer courts, and other relevant forums. This facet of her work underscores her commitment to ensuring fair and legal practices in the real estate sector, safeguarding the interest of apartment owners and association. Sneha's work in the real estate is particularly notable. She conducts title diligence and supports apartment owners associations in their operations and management. Apart from real estate, Sneha also deals with contractual disputes, insolvency and bankruptcy, shareholders disputes, labor and employment laws. She is adept in both domestic and international commercial arbitrations and has served as a sole arbitrator in domestic cases. We welcome you, ma'am.
Hi, good morning, everyone. So I'll be taking you through certain legal aspects, or I would call it legal issues that apartment associations generally face in a scheme of things. So today I'm going to discuss some of the issues, primarily these four, which is relating to association formation, handover process, common area issues, and vendor contracts. Association formation. What is important to note in association formation is today, a lot of apartments are either registered under Karnataka Apartment Ownership Act, the 1972 Act, or you have the Karnataka Cooperative Societies Act, the 59 Act. There are some associations that are registered under Karnataka Society Registration Act 1960, but there are certain issues with that which I will discuss when I go through this topic. So two main acts that I'm going to discuss about. One is Apartment Ownership Act and Cooperative Societies Act. The Karnataka High Court judgment, the Karnataka High Court in 2021 passed a judgment which said that Karnataka Apartment Ownership Act and the Karnataka Ownership of Flats Act are not mutually exclusive. Now, there is an issue. The reason this judgment came out is because if we look at the Karnataka Ownership of Flats Act, which is not an act where you register your apartment, but it is an act which deals with flat ownership. Now, this act primarily says that the builder or the developer should form an association under the Cooperative Societies Act or should form a company. Now, this act does not talk about formation of an apartment under Karnataka Apartment Ownership Act. So that sort of became a dichotomy, which the Karnataka High Court then intervened and said that, look, if you are registered as an association under the Karnataka Apartment Ownership Act, then the KOFA, which is the Karnataka Ownership of Flats Act, is not applicable to you. And only Karnataka Apartment of Ownership Act, KAOA, is applicable to you. So this was sort of, the dichotomy that existed got cleared when this judgment came up, because associations that are registered under the Karnataka Cooperative Societies Act, they have to follow the KOFA, which is the Ownership of Flats Act. While if you're registered under KOA, then you don't have to bother about the Karnataka Ownership of Flats Act. That's what this judgment says. So I'm going to deal with certain differences in terms of nomenclature because of the way the act is worded in this slide. Basically, first is about Karnataka Apartment Ownership Act, and then comes your Cooperative Societies Act. So because Karnataka Cooperative Societies Act does not deal with apartment association per se, people who are registered as a cooperative society also need an act that governs them, which then becomes your KOFA. So scope of the act, Karnataka Apartment Ownership Act, which I'm shortly going to refer to as KOA, and for Cooperative Societies Act, I'm going to call it KOFA. So that's how I'll be addressing. Now the scope is KAOA only, KOA is applicable only to residential apartments. Suppose you're a mixed development or you have all commercial and other establishments in your complex, then KOA does not become applicable. But people who have mixed developments or commercial complexes in their apartment can be registered under Karnataka Cooperative Societies Act. Then comes the process of registration. KAOA says to be registered as an association under KAOA, you need to register a DOD before the sub-registrar. DOD and other allied documents before the sub-registrar. Now there are two important aspects here. If the promoter or the developer registers this DOD, he has to do it prior to selling his first flat. If he does it post selling the flats, then such a DOD is non-est in law. The reason is, the act says that, look, you can register a DOD only if you are an owner. After selling all the flats, or even after selling, let's say 30% of the flats, the developer is no longer the owner. He only has few apartments left with him. So which means that at that particular point, whenever the DOD is being registered, it's important to see who was the owner. Today, there is a gap there because we have some of the clients who have this issue where after handover or during the time when people are saying, give me the handover, builder says, let me now register the DOD for you. He goes and registers. Now, the sub-registrar is not going to do a due diligence of who are the owners, because whatever you give is a document that they will believe and register it. So, having such a DOD where it is not executed by the owners on that particular date makes the association itself non-existent, which means it can be challenged tomorrow, and such an association cannot be called an association in the eyes of law. Now, Cooperative Societies Act, the registration process is completely different. What happens there is, there are certain forms, compliances. I think it generally takes between 3 to 6 months to form an association under Cooperative Societies Act. So you have to comply with whatever the demands of the rules are under the Act and before the registrar of cooperative society. So it ends there. In a cooperative society, the compliance is generally a little more compared to KOA. KOA has very minimal compliance. However, cooperative societies has a lot of compliance that needs to be done. Now, another important aspect. See, one more thing that we have to understand is KOA is an act that came about only for apartment associations. So the way the act is structured, it deals with a lot of issues that an apartment association can get into with the members. So one of the aspects are liability of unpaid expenses to the association. What the act says is that, look, if you're a flat owner and if you don't pay maintenance to the association, then the association can come after you and go to court and create a charge on the property. Now, it's not that you can't do it otherwise, but this is one of the specialities of the act, that it says that this is the right I'm giving the apartment association saying that if you have people who don't pay your maintenance regularly, make a claim against them and also create a charge on their property. While that is not there in KOFA, of course, cooperative society doesn't have anything to do with apartment associations, which is why KOFA becomes applicable if you are a association under cooperative societies. However, such a clause is not there. What KOFA says, on the other hand, is look, if somebody does not pay your common area maintenance, you as an association do not have the right to cut off the essential services. That is an important aspect, because some of the bylaws of certain associations say that in case somebody doesn't pay maintenance, punish them by cutting off services, which the law says, look, you cannot. And this sort of would also become applicable to KOA despite such a clause not being there, for a simple reason, because there are judgments by the courts to say that in the event somebody does not pay maintenance, you cannot cut off essential services like electricity, water, power, those services cannot be disconnected. Now, coming to common area maintenance, this is something that KAOA specifically addresses, saying what are the rights that you have in common area and how maintenance is supposed to be paid. Because one of the essential things under KAOA is that the builder or the promoter cannot retain any land in the common area. That's one of the things that KOA sort of captures. KOFA doesn't talk about common area as such. It only talks about flats between, flats sold by promoter, builder. That's pretty much what KOFA talks about. KOA, under KOA, if you are a registered association, then you're not a juristic person. The association is not a juristic person. But if you're registered as an association under Cooperative Societies Act, then you are a juristic person. What does this essentially mean? That under the eyes of law, you have a right to sue and be sued. So under KOA, if you want to file a suit, you have to file it in a representative capacity, because KOA is not a juristic person. However, under Karnataka Cooperative Societies Act, you are a juristic person, so you don't have to file a suit in a representative capacity. You can only file it in the name of the cooperative society. Transferability of membership. This is very interesting, because under KOA, what happens, suppose you're a second purchase of a flat. You don't buy it directly from the builder. Because if you're buying directly from the builder, and if the builder is registered a DOD, then you sign something called a Form B, where you're giving an undertaking saying that I am also submitting my flat to KOA. But let's assume you're a second purchaser. You automatically become a member of the association just by default, because you're already a member of the your apartment is already registered under KOA. However, that's not the case if you're a cooperative society. Every time a second purchaser or a third purchaser buys a flat, you have to consciously go and apply for a membership before the registrar. And it's in the hand of the registrar whether he allows it or he, does not or refuses but generally it's not refused. But that's the procedure where every time you have to go and make an application to become a member of the cooperative society. Coming to the undivided share, which I'll also be dealing with it at a later point, but just to give you an understanding of what the acts do, KOA says if you are an apartment association under KOA, then you are entitled to UDS, because the deed of declaration which is registered, that basically will have a table which tells you which flat has how much UDS. So by virtue of that, your UDS is already determined, and therefore UDS is given to each owner, or should be given, is what the act says. On the other hand, cooperative society says every developer should convey land and building to the flat owners. Essentially, it's just the way the act is worded, but both end up conveying the same thing. All of you, I'm assuming, have apartments and you know how your sale deed is structured. UDS is already given to you in the sale deed. Even assuming it's not there, UDS is not given to you in your DOD. By virtue of the sale deed, you've already been given UDS, which means that undivided share is with you. And the builder is bound to give you. The builder can't just sell the flat to you, but also has to give you UDS. That's what both KOA and KOFA convey. Now I'm going to just briefly tell you about the Karnataka Society Registration Act. Around 2018-19, the Karnataka High Court came down against this act, saying that those associations who are registered under Karnataka Society Registration Act, apartments specifically, this act does not apply to them for a simple reason that the objective of the act does not permit associations to collect maintenance. Therefore, since if you form an association, you don't have a right to collect maintenance, then under what authority are you functioning? Because one of the primary purpose of an apartment association is to maintain common areas. And to maintain common areas, you end up collecting common area maintenance from the flat owners, which KSR 1960 Act does not permit you to do. When the Act itself does not permit you to do, having such an association to govern or to collect maintenance, is again non-est in law. So the Karnataka High Court has heavily come down upon it. So in case you are an association under KSR, please see how you can move on to either a KOA registration or a cooperative society registration. So now coming to the handover process, before I start, I want to clarify one thing. Handover can happen through phases. Handover can happen through one shot. There is no process in law called handover. It is a general English word that we all use to say take a handover. But as such, in terms of how the law is structured, it's divided into many things. Many things amount to handover, at least under law. That's how it's looked at. So as an association, if you are today in the position where the builder is saying take a handover, that means you have to remember there are multiple things you'll have to do. One is, of course, one important aspect of the handover is you should have an association. That's very, very important. And if you don't have an association, then the first thing you do before you start the process of handover is form an association. Because otherwise, who's going to get the handover, or who's going to take up this handover process? Number one. Now, after you form an association, next thing is you need to conduct elections. You need to have your managing committee, your executive committee. That becomes very important. So that's the next thing you do. Now, third, because these are legal compliances. If you have these in place, then your handover process becomes smooth. Third thing is you need to start running your association, which means you need to either hire a property management service or you need to figure out vendors for each of your services. Get into contracts with them, which will also come to why those are important. Take up running of your apartment complex. That's, again, one part of handover. And another part of handover is to collect legal documents. Because all the title documents, the ownership documents of the land and building is with the developer. So now the association is saying, look, I am going to manage this entire complex. The land belongs to all of us who are members of this association. So therefore, please give me all the documents relating to this land and building. Because you as a builder don't have a right anymore. So that is another process. So there are two aspects here. Some associations do a complete due diligence of land because they want to understand how their land is structured. Because today I see that a lot of associations have this issue of Kharab land. Somewhere in their building they figure out there's a Kharab land and they don't know what to do. So either there is a pond that's already built by the developer, or some temple is constructed and they're figuring out what is this, right? Or there is an apartment or a building itself or a villamento or whatever it is that's already built on this Kharab land. So it is important as an association for you to know the nitty-gritties of your land. So a title diligence is always good if that is something that you can get done. If you don't want to look at title, then at least what you need to do is ensure that you know what are the legal documents relating to the land and building that you can ask the developer to give it to you in original. That's very important. That's another part of handover. And another leg of handover would be corpus. A lot of your sale deeds or when you're paying for your apartment, you will have a clause which says corpus is collected. What is this corpus? This corpus is basically collected from the builder that if anything was to change or if you need money to improvise something at a later point, then corpus is important. Now today I can safely tell you there are a lot of developers who are not collecting corpus because they know that this is becoming a problem that people are contesting. So some people are maybe collecting it indirectly, but the word corpus is not even mentioned, right? We recently had we recently had some client who had come in. There was no corpus at all, but that corpus was collected under a different heading, which made it seem like you can't take a refund, right? So these things become very important. And if corpus is something that your developer has, as a part of handover, it's important to collect that corpus. And there are many apartments who've gone to courts and gotten orders. But what is most important in this whole process of handover is to secure as much as possible you can from the builder. If there is a serious issue, then you move on to litigation, right? I mean, first you always try to solve things by any other means other than approaching court. But that doesn't mean you don't approach courts, because a lot of apartment associations have the fear either in terms of timeline or the outcome. But what is essential is that taking that step becomes essential than the outcome, because if you don't take that steps, that could lead to many problems over the years. Therefore, it's important to take that step. So these are some of the parts of handover. What I spoke to you about is only legal, but I'm sure there are other parts which other speakers will tell you in terms of handover what you need to look at. So just one more aspect today, there is a problem that I see is regarding occupancy certificate. I see that a lot of flat owners today have taken possession of their flats already before an OC is issued. Or in between construction, for whatever, either the pressures created by the builder, etc., whatever it could be, but possession is already taken before OCs come. And they're waiting for the OC to come after possession is taken, right? Or OCs never come, they are in possession for many years. Then what do? Let's look at what does the law say about occupancy certificate. Now under RERA, promoter is responsible to collect the OC. The liability of collecting the OC or getting the OC done is on the developer or the promoter. It is not on the flat owners or the association for that matter. There are some judgments that have already been, given regarding OC. The National Consumer Disputes Redressal Commission has said a couple of things. One being that OC has to be collected by the promoter, and in the event OC is not collected, compensation is given to flat owners. Also, recently there was another judgment which came out which said that, look, if OC is not given by the promoter, you don't have to pay maintenance. The builder is supposed to maintain or do whatever it takes to keep the apartment complex running without you having to pay OC. The reason this has come out is it is very important to note that you should not occupy your flat without an OC. That's number one, very important. And even assuming under whatever pressure you have occupied your flat without an OC, you can protest and say, I'm not going to pay maintenance, because the obligation is on you, the promoter, to have first collected the OC. Because what does OC mean? OC means that, look, the building is ready to be occupied. There is electricity, there's water, there's whatever you need for common area, living. So your living is safe. If you don't have OC, that means this building is not in a shape where you can even live. When that is the case, where is the question of paying maintenance? Right? So that's the reason this judgment came out. And the Supreme Court as well, in this Debashish Sinha's case, has said that it is again the duty of the promoter to obtain OC. It is not on the flat owners. Flat owners can file a case before RERA, claim compensation if OC is not given. Now, coming to common area issues. Now, what is common area? Anything other than the four walls of your apartment. The minute you step out of the door of your flat, everything becomes common area. Right from your lobbies, your lift, your parks, your football ground, your swimming pool, your clubhouse, any space that is commonly used by a flat owner, other than, of course, the flat which you reside in, everything becomes OC, common area. So just this is a slide where to show you what contributes to common area. Even your STP, your water treatment, all that also becomes part of the common area. It's something that everybody can use commonly. So before we move into certain issues that you face in common area, let's look at what the law says. Section 6 of KAOA says every apartment owner shall be entitled to an undivided interest in the common areas and facilities in the percentage expressed in the deed of declaration. which I already told you, that in the deed of declaration, you'll generally find a table where there is a flat number. What is the UDS? What is the super built up area of each flat? Now, it is very, very important to calculate the entire UDS of all flat owners to understand that the total of that UDS should add up to the extent of land. Now, if the math here is gone wrong, that means there is a problem. And you need to approach lawyers to sort of solve this issue for you, because this is a very big problem. Either builder has given you more land than what your apartment complex is constructed on. That is one issue that people face. Or you've been given less land where the builder has retained some bit of land for himself or not sold it, right? Which is not allowed in law. Both scenarios are not allowed in law. So if your UDS, your total UDS of all flat owners do not add up to the extent of land, that means you need to go take legal recourse. Now, what does RERA say? RERA says promoter shall execute a registered conveyance deed in favor of the allottee along with the undivided proportionate title in the common areas of the association. So RERA has worded this very differently. So far, this aspect is not implemented as such. RERA says that, look, all the common areas have to be registered through a conveyance deed to the association. Now, the reason this is not implemented the way the act is worded is because the UDS is already being sold to the flat owners under their sale deed. So, since the UDS is already sold, how can there be another conveyance deed only for common area? So, that is sort of the gap. So, the way the act is worded to what is being followed, there is a gap, but the intent remains that, look, developer, you cannot hold any share in the land. All the UDS of the entire land has to be given to the association. Now, with respect to common area, two issues that I want to bring to everybody's attention, right? One is car park. Car park is a common area. And this is something that everybody knows. What happens generally is by the time you finish your handover process, which let's say 3 or 4 years since everybody occupies, the builder manages to sell all the car park. So I would say as an association, the first thing you need to do when you form your association and you have your MC is please take stock of the car parks. Depending on your super built up area, every flat owner is allotted with 1 or 2 car parks mandated by law. Now there are many, it's not that every apartment has 1 or 2 and only that many car parks exist. The law says that you need to have 10% extra, so on and so forth. So the car parks are always in excess of how many number of flats there are, which means that every other car park that is not allotted to a flat owner through his sale deed is a common area car park, which the builder absolutely has no right in law to sell it and make money out of it. But every developer is doing it. And the only way you can solve this issue is the minute you form an association, take stock of how many extra car parks there are, go file a suit for injunction, restrain the developer from selling further car parks, and take hold of because those common car parks are required for the association to run and maintain. Once car parks are sold, it's very difficult to undo, right? It's not that you can't, but it's difficult to undo, and a lot of associations don't care. They don't know how lucrative that entire part of this common area car park is because it's not looked at, right? So that is one important thing that association should note. Second thing is regarding STP. This is a perpetual problem with most apartment associations, at least that I have come across, that there is an issue with the way STP is functioning. Please understand that once you have formed your association and you have an AC team, you can't pass on the liability to the developer saying you take care. It's not that you can't pass on the liability. Let me just reword that. The builder will not make that correction. And what you need to understand as an apartment association is there are criminal liability that comes along with STP, right? So it's very important for you to rectify the issues that you have with your STP, and then please then go after the builder and claim for damages. Nothing stops you. But to take that step to rectify your STP is very, very important. Because once KSPCB comes after you, they will keep coming. And please don't take the other route. But what you should do is please rectify your STP. That is a correct thing that you have to do to rectify your STP, make it completely functional, then you go after your builder and say, please pay me this. I have spent X amount of money because you did not give me a right STP at the time of handover, or when you built it itself, there was an issue. Get experts to come and give you a report on how your STP is before starting the work. And once the work is done, establish what the difference was. Now, when you go after the builder, these kind of expert opinions and reports will actually come handy. So this is how you have to deal with STP issue, not ignore it, push it by the side and say, let the builder come and do it. Even if it amounts to gathering money from each flat owner to repair the STP, I would say that is probably the way you should do. I'll take all questions once I just finish my thing. The last aspect is vendor contracts. This seems to be a neglected part in many associations. People start looking at vendor contracts only after they get into an issue. Now, what we need to understand is contract. The reason contract exists is to protect you. Put all the rights, liabilities, obligations in place, and they actually protect you. They cause you less damage, less harm than they are supposed to. I wish I had more time. I would give you examples of how we have dealt with contractual disputes for apartments. But due to lack of time, I'm only going to tell you that it's very important to protect your association members by ensuring your contracts are vetted. Don't just blindly sign contracts that are sent by vendors. Understand what your liabilities are. You need to be indemnified. You need to know the commercials. And a lot of apartment associations, despite having commercial terms in their contract, are not able to recover that money, which means it's an added problem. So it's very important to look at your vendor contract very seriously and ensure that there is no liability cast on you. Because no vendor should commit an act, or the property management service, when they send their subcontractors on board, there should not be a position where you have labor law issues. And see, because some of these actually have criminal implications. We don't understand. And you could also be subjected to damages, right? Or suppose you hire someone and they're not performing their services. You won't know what to do. It'll be difficult for you to send them out. So then you are actually having a vendor who is mediocre in your property, which means the value of your property is decreasing, right? Your property is not the way, it's not running in the condition it's supposed to run. So vendor contracts have to be looked at very, very seriously. Thank you very much. I think I'll just end my presentation. Yeah. Thank you. I can take questions now.
Hi, good morning and thank you very much. I come from Gina Shalam apartment.
Hi.
So our apartment is registered under KSRA. So this has been registered in 2016. My question is going to be a little specific. So you have mentioned it's supposed to be mandatory. I would like to know how many apartments in Bangalore have actually moved to this because it's saying mandatory. Second thing, how long will this process take to do? And how high will be the cost of moving to that? And how long will it take, knowing that the government process is there for that?
So your question is very specific, but I'll give you a very generic answer so it will help a lot of people. I can't comment on the cost, of course. What I can tell you is if you're under KSR, you really need to look at moving to either KAOA or Cooperative Societies Act. There are, you may have to approach a lawyer and get the work done. Yes, it's going to take you 3 to 6 months, but making that transition today is going to help you in the future. But sitting as a KSR apartment is always going to be a threat to run the apartment.
Ma'am, I'm from Spark West apartment. So we are registered as a KOA and DOD right from the beginning. Let's assume for a moment when you talked about the importance of the date of registration of DOD. Let's assume for a moment it is registered before the sale of apartments. My question is, I mean, there's a lot of noise in the apartment RWR and the members about moving to Cooperative Societies Act. Is there any merit in such things? Is it really needed, or does KOA allow us association to function, collect CAM, collect sinking fund, maintain funds, whatever, right? Is there just the noise? I mean, there's a lot of noise around.
Yeah.
Is there
So
a need to move?
I'll answer that question in today's perspective. there are a couple of PILs that are pending in the High Court of Karnataka challenging the KOA, but so far there have been no orders from the court. And KOA is a law meant for apartment associations. So today, if you're asking me that question, my answer would be that you're safe. You are a registered apartment. You may not be a juristic person like I explained, but you are a registered apartment that can collect maintenance, perform its necessary actions to maintain common area. There is absolutely no threat. So I would say that only if the judgment comes out to say, everybody now please move to a cooperative society or, some other form of association, that's when you look at moving. But as of today, you are safe. You don't need to think about registering under any other act.
Good morning. Good morning. Firstly, thank you very much for a very crystal clear discourse on a topic which was very nebulous to all of us.
Thank you.
I just got two very quick questions. As per the Karnataka Apartment Owners Act 1972, it says that the maintenance charges are to be collected pro rata of the super built area. But there's been a lot of discussion in our society. We've got 3 BHK, 2 and 2.5. Logical argument is that everybody is using common services, swimming pool, gym, lifts, water, and water is more proportional to the number of residents in a flat rather than this thing. So, although Karnataka Apartment Owners Act says that it should be proportional, can the AGM, is it under the purview of the AGM to discuss this in the AGM and pass an amendment to have a differential rate for the 3 configurations of the flats?
So just to answer the last part of your question, no, because then you are overpowering the act itself, which you cannot. Because your bylaws are in consonance with the act, and the actions that you take in your AGM or through your MC should be in consonance with your bylaw and the act. So therefore you can't overpower the act. But I do understand, in fact, we are fighting litigation for a couple of associations on this very point. So it's probably a little too soon for me to comment, considering there is no established law. So far, there are no judgment that has come out on this very point. But I can have an academic discussion with you after the session.
Okay, one very short one. About the car park, it is an eye-opener. In fact, after we took stock of the car park, there were many vacant parks. So our association thought we will take over. But what some of the residents did is, they went to the builder. They just got a letter that this has been allotted to them, paying 1 lakh. So now I understand it's illegal.
You can challenge it, sir. You can challenge.
Okay, thank you.
Yeah. Hi, Sneha. Yes. My question is, should we compulsorily be registered? Can we come out of a KSRA, and can we dismember and not be a registered one?
Yes, of course. You can register. You can, even though you have an association right now under KSR, you can move to a KAOA or a cooperative society and start running the association under that, under the new.
My question is can we move out of all these acts and not be a member of any of these acts?
So, but then how will you? I understand that. But then how will you how will you run your maintenance? Who will pay you money, right? There should be some body that is answerable to the residents. There should be somebody that's willing to, because KOA says the association is the custodian of common area. It's giving you that power. So when you're getting that power, and if you're saying I don't want it, then how are you going to be governed? And it is not that you can't run it, but tomorrow if you run it and if you have issues, then how are you going to deal with it? That becomes the bigger question.
Right. Unregistered apartments are there, no? What is
there
a,
are AOPs.
Percentage?
I have not done a survey, but I know that there have been EOPs that are functioning. Maybe it works when you're 8 or 10 apartments, but the minute you're a large apartment, for you to get control over, let's say 200 flats or 200 flat owners, it's nearly impossible without a legislation. The reason you need law is so that the minute the numbers are more, everything is not trust-based, right? After a point, you need a legal system that's helping you, because you can't run it just based on trust. So the legislation only helps you to be better, govern better, actually claim your rights.
Can I? Yeah. First if I'm already registered as an apartment under the Societies Act, is it mandatory to move from the Societies Act registration to a KOA?
I would say it is mandatory to move your association. Now, whether you make a choice of KOA or cooperative society, that's left to you. That's a discussion you can have internally and decide. But I would say it is mandatory at this point because at any point your registration can be cancelled by the court of law.
So it is mandatory to move from
I
a
would say
society
yes.
registration
Yes.
to an apartment
Yes.
KOA registration.
Yes.
Okay. Second question, you mentioned about the, it's all very, very simple, 30 seconds for her to answer, right? The car park is the undivided share. So the area outside the car park, does the MC or through an AGM have the right to create two-wheeler parks in the open areas which are lined out?
See, what happens is, it's not about right or not. You have a sanction plan already in place. Now, when you deviate, the law says you can deviate about 5 or 10%, right? If the deviation is more than that, then your OC can be cancelled. Because what you're talking about is structural change. So either you need to go and apply for the sanction to, for your two-wheelers, or you have to ensure that the two-wheeler parking that you want to build is not more than the deviated permission limit by the laws.
Not building, marking.
It's the same thing,
it's the
yeah.
same.
Because your apartment is supposed to be constructed exactly like how your sanction plan is. Because every common area is already given a particular space. So if you're deviating from that, it amounts to deviation.
Third one, on the CCTV, no, I have to finish this, 30 seconds. CCTV installed by the management association, can an association, MC install CCTVs in open common areas without informing the residents about it?
My take on this is my personal opinion. There is no law on this point, but I would say every act that the association, does should be ratified by the GB. It's only because numbers always speak. Where are you deriving your right from? Right? Like, who are you to decide without? It's a collective decision that we're always looking at when we talk about associations and not individual members' decision.
Great.
So I would say.
Thank you.
Good morning, ma'am.
Hello.
Hello. My question is, you mentioned that, 1960 Act, those registered, they can move over to KOA or cooperative society. Now, you also mentioned that the builder is the person who can, register the DOD under KOA. Now, how will the already registered 1960 move to KOA?
No. So what I said is that you have an option to move to KOA, but let's say today, after the builder has sold all the apartments, if you have to form an association under KOA, all the owners have to come together and sign. The builder cannot. The builder only has a right to form the DOD prior to the first sale of the flat. After that, he doesn't become the owner. Let's say he's retained 10 flats, then he comes and signs only for those 10 flats. The remaining owners have to come together to form.
Under what section is it mentioned, ma'am? KOA?
I'll look it up and tell you. Yeah.
Thank you. Thank you.
Ma'am, I am Commander Raghunath. I will read out what it is rather than putting my interpretation of it, and you can interpret and tell me. It is from moneycontrol.com site. The Karnataka government has clarified that the Resident Welfare Association cannot be registered under the Karnataka Apartment Ownership Act 1972. In a right of information reply dated January 6, 2023, accessed by Money Control, the Legal Department of State Government has said that Karnataka Societies Registration Act, KSRA 1960 and KAOA 72 does not allow registration of RWAs. Thank you.
It's a newspaper article, so I'm not going to treat that as, it's a newspaper article. I'm going to leave it at that. But I will clarify. So we have to understand that the state of Karnataka is representing in this PIL. They are a party. Now they are making a lot of submissions in the court in this PIL, and through that they have issued certain notifications. The way I would look at it is currently, because the matter is sub judice and court has not passed any orders, I would not go by that, because today legally it is permissible for you to register. A government notification cannot come contrary to either the court or the act itself. And if such a notification comes, it is subject to challenge. But if so far, because there is no court order, I wouldn't go with that article.
Yeah, as I know,
recently came to know that Cooperative Society Act will be the future and KOA will be phased out. Maybe there will be a transition to that is 1959 Cooperative Act.
How did you come to know this, sir? Because
Yeah,
I have not come to know
because
this.
we want to do the registration, and most of the, I mean, we contacted. They say Cooperative Society Act is the right one, because you have the right to sue or get sued, and also land registration will be taken care by the Cooperative Act, but KOA it's not there in that.
So as an association, you need to make an informed choice when there are two choices given to you. So each opinion that's going to come to you is going to be different. My opinion may be different, another lawyer's opinion may be different. So of course, based on the opinions that you get to make that decision. But if your question is, can I register in either? I would say yes. If your question is, should I only do it in KSR? My answer to that is, KOA is also an act. You can look at both and make your decision. But is KOA valid? As of today, absolutely, it is.
We are very happy to be associated with Namidi. I'm coming from Prestige, Falcon City. You are the consultant. So, I mean, you have done a wonderful work. Almost 6 GB of data has been.
Thank you.
Especially in the as part of many of the punch list points, etc., etc. Now, coming to the points. Now, first question is about the land survey. As per the approved plan and the existing construction, there is a discrepancy of around 3 acres and all. I mean, this has been put to the developer or the Prestige Group, and is there a timeline that they have to come back and give us this information?
Sir, I would say more than them coming back,
Yeah.
you have to exercise your legal right in time.
Okay.
From the time you know that there is an issue, ideally within 3 years, you should try to go to the court and seek for recourse. Because what developers do is they will ask you to wait. They will make you wait because they know the law of limitation better than you do.
Okay.
They will make you wait until you lose out on your limitation.
Okay.
And then you don't have recourse. And then they will not give you the answer.
I know the first step is like, I mean, establishing the, what do you call, the missing land, that is okay, through email and other things. I mean, the very next step should be going to the court directly, or is there a mediation is possible to have a meeting with these guys and try to solve it off, or we just have to go?
I can take this up because this is very specific to your apartment.
Okay,
I can
okay.
take this up maybe during the break.
Okay. The second question is about the STP. I mean, there are issues with the STP. It's very well known. Since the system is not handed over to us as the association, does it have any, what do you call, I mean, whatever the corrections or the repairs or anything to be done on the STP, is it in the scope of the Prestige, or it is with us?
Right. So this is a very interesting question, and I'm going to answer it to everybody, not just to Falcon. Today what is happening is first thing that I would put across before I answer this question is, please don't shy away from the problem. Today associations are shying away from the problem, not because they want to, but they subconsciously think it's the liability of the builder. Yes, I would agree it is a liability of the builder, but by just pushing the liability, palming the liability off to the builder is not going to help you. The way I would look at it is resolve the issue, then you go after the builder. You have to tell the builder, look, you come and fix, and give him a timeline. Let's say you come and do this within a month's time. Issue a legal notice, do whatever is required. And if he doesn't come and do it, please take it up and get it done, and then go after the builder. Because what you're doing by palming it off to the builder is just sitting on the problem. And after some years, he'll say that it's not my responsibility. And how are you going to prove that when you took handover, there was an issue? He will say the issue is cropped up now. Defect liability period is over. Why should I help you? This is actually a very big problem. So the way I would address this issue is by taking recourse today, making the change to my STP today, and then going after the builder. Because please understand, every legal solution comes with limitation. You have a timeline within which you can make your claims, seek for legal recourse. And if you have missed that, then there is nothing you can do, even though you've had a great, even though you've had a problem which the builder has to take onus. So I would say fix it and then go after the builder.
So I'm talking about from the perspective of a general member of an association. So there is a grievance redressal where it has to go, because if he is having any findings on the misappropriation of the funds, or if it is going to be about the way the elections are conducted, so where a general member is going to raise his, unlike now, recently we saw that the cooperative societies in Mumbai has done this as an online platform also, just
So
by paying 50 rupees.
let's start, just before you finish, don't compare Karnataka to Bombay. Bombay's dealt with flats for many years. To Karnataka, this whole concept of community living is very new. And we don't have the laws that Bombay has. And Bombay comes with a big segment of associations that are willing to fight out with the builder, which is not, our cultural upbringing, I would say, or the way we're constituted. So we can't draw a comparison. Now you can continue.
But the Act very clearly says there is a competent authority, which is the cooperative society registrar. But when we approach the registrar says he doesn't have any power and he is not going to entertain any queries on any misappropriation of funds. So now the general member is left in a crunch that where actually he is going to raise his concerns or a grievance, because finally it ends up only with the boardroom, meeting room where the EC or the MC members are sitting. So is this the only thing that even for such a small thing you'll have to go and file a petition or go to the civil court?
So as a lawyer, I would say there is no difference when you come to me to go to court or to the registrar, right? Because I'm addressing the same problem. Even in terms of timeline, having done a couple of matters both in civil and registrar, I can tell you it's very close. You're not saving any time by going to the registrar. So I would say more than looking at it from a point of view of who the competent authority is. Because for KAOA, the competent authority is court. Yes, there is the registrar who is the competent authority under the Act, but there are no rules imposed on him to perform his duties. So he says, I don't have anything, which is fair. That is a problem with the Act and the rules, which the government needs to correct. But given the fact that the laws are the way they are today, as an association for you, either you go to court for the same problems that you have, or you go before the registrar if you're a cooperative society. I personally don't see any difference between the two. So that is a choice, again, that you want to make. But do you have recourse under both? Absolutely.
Good morning.
Good morning.
We are from Windmills of Your Mind at Whitefield. I have three very quick questions. You mentioned our DOD was filed by the builder 10 years ago, and we are a total of 405 units. Mentioned in the DOD is about 256 names of owners. You mentioned that all the owners have to be specifically mentioned in the DOD. Do we need to have an amendment in a DOD consequently?
I may have to look at your DOD to answer that question. I think it'll be better if we, look at your document and...
The other point I have is that the insurance of the building against fire and other risks, in whose name should the insurance stand?
So you can transfer it to the name of the association. I would say association.
If it is standing in the name of the builder?
You have to transfer it. So when the renewal comes,
Yes.
you can do the renewal and get it transferred to the association's name.
Is it compulsory that he has to hand over to us? Or can it?
See, ideally, yes, he needs to assist you in this transition, because once you take over, you will have to pay the insurance, right? I mean, he's not going to pay the premium. So you'll be paying it. So ideally, it's always good if it's in the name of the association.
We are paying it to the builder.
Then you should insist that he transfers your name, or talk to the insurance company directly and take it up and say this is an issue.
Does a DOD convey the property in the name of the association automatically, or is there a separate conveyance deed?
So no, KOA, the very act itself says undivided should be conveyed by way of the DOD, but the act also says that if that is not happened, just by the fact that your sale deeds have the UDS, it's automatically conveyed.
It's mentioned in the DOD and in the sale deeds.
Perfect. So you don't have a problem at all. I don't see how this
There's
is
no
a problem.
stamp duty involved.
For transfer of fire insurance? Absolutely not. No.
And for transfer of title, in whose name does the title stand?
So title is a little, let me just explain. I think this is a question that I could talk to the entire audience. Today, if you take khata for the land, it is going to stand in the name of either the landowner or the developer, right? Now what happens is this khata of the land, once apartments are constructed, gets bifurcated through a DC order. So there is a bifurcation order saying that now this PID number, whatever number, the survey number, has been divided into 400 survey numbers, with each flat getting their own recognized number. But if you go and apply for the old khata, you will get this. They will give you the land khata because you are asking for the entire survey number. Let's assume your survey number is constructed on survey number 12. If you ask for a khata of survey number 12, you will get the land khata. Now that is not the problem with the law. That is the problem of how the system is. It's not our problem nor the legal issue. Because then if I get the bifurcation, the way I would look at this issue as a lawyer is when I look at the land khata, I will ask for a bifurcation order. And if I have that bifurcation order, I know how many sub-khatas are made. Now considering there are those sub-khatas for each apartment, then that sort of collective kata becomes the land kata. Even though, yes, if it would change, it would be better, but that is a system implementation issue.
Last question. You mentioned that we are not a jurisdictional body under KOA. Now, in case of a suit being filed, or we being filed against, suit being filed against us, who is the representative person?
So what we do, I'll try to simplify it, but in law, the way we do it is, the association will be a party, right? We make some of the EC members a party in the suit. And then we file an application, which the procedural law permits us, saying that these people or the association is being represented by all the owners. So it is a simple application that we file in court to say that this association is being represented by all the members. So that sort of cures the defect of the association not being a juristic person.
The question was because the MC or the EC changes every year.
Fair. One application, if the court allows, then there is no issue, which it will get allowed.
Thank you. I'm going to ask questions from online representatives. We have a Mr. Ganesh Kumar who asks about KAOA. In addition to the KAOA, do we need to register under 1959
No.
too? No. To get juristic identity, or is the MC authorized to file legal case? I think this was answered.
This was answered.
Yeah. Mr. Ganesh Kumar continues about OC. What to do if builder is not getting OC even after waiting for years?
Please file a complaint. If you're a RERA registered, please file a RERA complaint with the RERA. You will get compensation and the OC.
Perfect.
At least a direction for the builder. Yeah. The liability, please understand what we need to look at from an apartment association point of view. Please pass on the liability to the developer. And the only way you can pass on liability to the developer is not by issuing notice or sending communication, but actually taking legal recourse, getting the court to direct the builder to perform these actions. Because if the builder is not performing actions based on your request, then there should be a competent authority that is telling the builder, look, do your job, which is the court of law. So taking that first step is very, very important, because if you've taken that step, then your defense can be that, look, I have passed on the liability, now I'm waiting for the court to give me a direction. But that step, that is something that you need to take.
Last question. What exactly is the risk of the builder retaining UDS? Can they build something in the unclaimed portion?
Legally, they cannot. Legally, they cannot even retain UDS, forget building. But builders are doing it today. And this is what I mean, that if you don't take that step, if you don't go to the court of law and make your claim, the builders are going to do whatever they want. And to undo the damage, let's say there is a structure that's come up, which is not part of your sanction plan. To bring that building down is not easy. Is a very long battle that you're fighting. And we also have to understand, let's say there's an additional building or a tower that gets built or a common area. When you try to bring that down, it's also going to affect the lives of people who have bought that for whatever reasons, legal or illegal. So why even go to a point where you have allowed the developer to make that damage? All we need to do is just be slightly aware and take action before the problem comes in.
Thank you.
Thank you. Thank you all.
Thank you for this wonderful presentation, ma'am. I now call Vasanta to hand over sapling to you.